may be true that we seem to like a lot of talking in this climb more than action, it is also important to emphasize the position of talking, discussions, and dialogue in fashioning the way forward for action. On this program, on the scale, we have at various times focused on efforts to move the state forward in terms of having summits and discussions on key areas in the justice sector. And so when we also hear that there is a major summit on the justice sector that is being organized to fashion up the ways where the justice sector can play its role effectively as a third arm of government, the scale has to pique a lot of interest. And so that's what we're going to focus on largely on the program today. Welcome to the scale. I am Femi Okeowo. There is a Justice Sector Summit that has just been held in Abuja. It is very important in fashioning the way forward, but then also looking at the past to see how well the justice sector has functioned as a third arm of government. It is so important that the Vice President of Nigeria attended that summit. And that is what we're going to be focusing largely on this program. At least we're going to start with that Justice Sector Summit. Here is Olabode Arewa with a summary of what happened at that summit.
It is often said that the judiciary is the last hope of the common man, but several reasons have been adduced for the erosion of trust in the judicial process. These include the slowness of judicial proceedings and perceived external influences on court decisions. Participants at the summit identified the quality of judicial decisions to be tied to the quality of those appointed as judicial officers. Hence, they want the process to be overhauled to include proficiency tests for them.
As it is today, regardless of the capacity, competence, and integrity of a senior advocate that is desirous of taking up an appointment as a justice of the Supreme Court, it is becoming practically impossible on account of the guidelines that are designed to ensure at the end of the day that appointments are localized through judicial process.
Because the issues are related, permit me to step back and look at the issue of appointment and selection again. Because it has a direct bearing on how efficient the system can be, the issue of appointments. So when we confronted, and we're here for practical solutions, right? And we want to speak frankly. When I saw the process by which Justice of the Court of Appeal, potential Justice of the Court of Appeal were about to be selected, so I asked questions. Okay, before this 20 or so, 40 or so applicants, let me call them applicants, got here, what process did they go through?
We have these institutional weaknesses there. Coming back to how the system works, particularly at the appellate level, we see that some of the pathologies that affect appointments even into high courts also affect the system of appointments to appellate courts. You don't have any system that provides verifiable information that the criteria that ought to have been used in appointing those appellate judges were actually used. The system is structured in such a way that it very easily can provide us subjective results, but pass it off as objective results. And there is really no system for interrogating the integrity of what has been produced or the outcomes of that process.
I will quickly opt for a proficiency test. One, it eliminates the use of maneuvering, at least to a very great or large extent. Number two is that you are sure of where to turn attention to. And I will categorize this into three. One, to test his knowledge of law. Number two, that is to examine the head, examination. You know, it also engenders public confidence when they know that the person who has been appointed is competent. You won't be talking of any other thing.
Things must change. Things must change. And we have to gear up to effect that change. We can't wait for our children to come and do it.
As alluded to, while discussing judges' performance evaluation, the delays in justice dispensation has been severally described by the organizers as being an embarrassment and deserving of derogatory comments from foreign courts. The image that seems to have bedeviled the judiciary is easily traceable to various factors such as accusations of compromise and manipulations from other arms of government and from politicians. This has been further heightened by the inability of the court system to handle the existing caseload. Upon fair, deep, and dispassionate reflection, it may not be difficult to see the factors and actors responsible for the unfortunate situation. Those complaining the loudest may even bear the largest responsibility.
Vice President Yemi Osinbajo, who also lent his voice to this call, said that obedience to the rule of law was in the best interest of all.
The truth of the matter is that the responsibilities of the judge, or justice, as you have, of the Supreme Court or the Court of Appeal, are such that they must be well regulated. They are such that if they retire, and when they do retire, they must be able to go to homes of their own, that they own, in decent places where they live. That's the way it should be. We should not have a situation where judges are anxious that when they retire, they will not have homes to go to. And because their salaries today simply cannot build any decent home. So we must ensure that these things, that these are the conditions that are met. We must strengthen the process of reviewing performance, incentivizing excellence, and penalizing misconduct. There's also no question at all that the expeditious delivery of justice cannot wait any longer. The reputation of our system for repeatedly resulting in what the UK Court of Appeal described as catastrophic delays must be reversed.
The summit also identified adequate funding and other bottlenecks hindering access to justice.
We are talking about more funding for the judiciary. Unfortunately, we have 17 trillion as national budget this year. And the percentage of the money given to judiciary, 110 billion. I appreciate, Mr. President, for the increase since 2009, adding 10 billion in 2019, 2020, 2019, 2020, and 2022 budget. It's quite, we appreciate, Mr. President, for that effort. But if we look at the totality, today, 17 trillion naira budget, and the judiciary has 110 billion. That is 0.7% of the national budget. And that's why at the legislature, we started a campaign for a special intervention fund. I saw that reflected in the speech of the NBA president as what is obtainable in India. The judiciary submitted a budget of about 187 billion to the executive. And then the executive, in their wisdom, pruned it and then brought it to, I think, about 110 for under the statutory transfer. Is there a possibility? I know that we are not trying to take the powers of the executive. Is there a possibility for, still independent of the judiciary, for the judiciary to submit its budget directly to the National Assembly, so that the National Assembly, starting with the responsibility of appropriation, can look at this budget and directly.
The summit applauded the ongoing adoption of ICT facilities across court jurisdictions in the country for virtual proceedings as a needed tonic for the nation's development.
Yes, critical issues that are being raised about the past and about the future and wanting to know how the justice sector can aid our democracy and developmental goals in Nigeria. Next, we go to an act that has been enacted. We all know the dangers of being caught up in any security breach, and most of the time, the innocent are the ones that suffer it. There is an act that guarantees that people who suffer gunshots should not be abandoned. Indeed, it is an obligation for the health sector to take care of anyone who suffers any gunshot wound. And that act is what Dele Atumbi is going to look at, how it would affect both the socio-economic position in Nigeria and indeed our movement generally in terms of security. Here is Dele Atumbi with that story.
Due to the sanctity of human life, right to life is one of the bundles of rights enshrined in Section 33 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. If not for few exceptions, right to life is part of the rights that are unbrogable. To further ensure that this right is protected, the National Assembly enacted the Compulsory Treatment and Care for Victims of Gunshots Act 2017. This act is to cure the defect of victims of gunshots not being treated without police report, as some lives have been lost in this process.
The right of a gunshot victim has been shortchanged over the years, and that is why in 2017 the act to protect that right was actually promulgated, if I will use that word, by the National Assembly. That was a very, very good act. And that was a very positive one, a very short one, but very, very, very concise and all-embracing. You know, the act considered the position of the victim, gunshot victim, the position of a volunteer that brings him or her to a medical center for help, the right of the victim to actually be treated, the position and the duties of the medical facility, the chief medical officer, the security agents, and even the relatives of the victim. Before then and even now, you realize that gunshot victims are treated as pariahs. They are treated as people criminals who are actually escaping from the scene of crime. And so everybody would naturally run away from such victims.
It was rooted in the policy of government, federal government of Nigeria, that because of incessant cases of victims of gunshots, innocent victims who are left to die or to suffer massive damage because of lack of treatment when such injury occurred. In the past, such people are left to die, as I said. But government, in its wisdom, decided that that should not be the case. Particularly, if you look at the provisions of the Constitution of the Federal Republic of Nigeria, particularly Section 33 of the Constitution that provided for right to life. So if we have right to life, would it be fair to allow somebody who suffered such injury to die or to be left uncared for because of one fear